The NUM is threatening Eskom with legal action. It follows Eskom's decision to unilaterally implement a 1.5% salary increase. The union says this is unlawful. You'll recall the wage talks ended earlier this month with Eskom declaring a dispute when it could not reach agreement with the unions. Let's discuss this with the union's energy sector coordinator, Khangela Baloyi, who joins us now virtually from Cape Town. Mr. Baloyi, thank you very much for your time here on eNCA. Now, of course, as a people, we would all agree that a 1.5% salary increase is basically a slap in the face. But explain to us in terms of the legal avenue that you're taking, how are you going to argue in court that the decision by Eskom is in fact illegal?
Yes, no, we view this decision as illegal, and these are the reasons why we say this decision is illegal. You see, Eskom is designated as essential services. What does that mean? It means workers of Eskom are not allowed to go on strike by law, even after receiving the certificate of non-resolution. So the processes that follows are guided by Section 74 of the LRA, whereby it allows us to go for what is called interest arbitration. So before that takes place, Eskom decides to implement the 1.5%. So as the NUM, we believe that Eskom is abusing the fact that Eskom employees are essential service workers and cannot go on strike. You see, the constitution of the country allows every worker in South Africa to go on strike. However, that right of striking is limited by the LRA, which after that limit, the LRA gives an alternative on what you must do if you can't go on strike, because you can't limit someone's rights and not provide a recourse. So the LRA provides a recourse on what must you do if there's a dispute of interest in an essential services company, or in a company that is designated essential services.
Now we know, Mr. Baloyi, that talks were basically, broken down. They broke down on the 2nd of June, and the unions were calling for 15%. Of course, a 1.5% offer that is on the table is, we would agree is unjust. And in the meantime, Eskom does keep applying for NERSA to allow it to actually up its tariff hikes. How do your members feel about that part? The fact that, yes, the Eskom management keeps complaining that Eskom is cash-strapped, etc., but you're seeing consumers paying more for electricity, but the workers being paid less or offered less.
You see, Eskom is making 200 billion per annum as a revenue. That's a lot of money, you agree with me. The problem with Eskom is the management of this money. You see, most of the money goes to primary energy, which is coal, diesel, and other source of energy. So, and the second highest cost is the cost of the IPPs, how we service the power purchase agreement. You see, we are buying electricity from the IPPs on an average price of R2.14, and only to sell that at 89 cents. And that shortfall is paid by Eskom. So some of the money goes to that. And we have been saying, we're on record as the NUM saying that this relationship between Eskom, government, and the IPPs is going to kill Eskom, because it's milking Eskom. You see, and we don't understand why Eskom management does not see that, And workers of Eskom are suffering. You agree with me, 1.5% is the same as it did not get anything. And it's not only, they are not only saying they are giving us 1.5%, they're saying they're giving us 1.5% only if we agree on the down variation of some of the conditions of service. And when you look at the conditions of service that they are talking about, you will notice that actually they are giving us less and take more from us. That's what they are proposing. They are proposing what we call a self-funding model, whereby they take something from us, and then from that they give us the 1.5%, but they still left with more of the money from the conditions of service that they want to down barriers. And they want to implement that unilaterally, you see, which is not allowed by law. Because we're supposed to negotiate the conditions of service.
Yes, be in discussions.
Out of the negotiation table, remember, and refer the case to CCMA. Now that we only did the conciliation at CCMA, because the process of CCMA starts from conciliation and mediation, and if that does not work, you must go for arbitration as per Section 74 of the LRA. But Eskom now decided to implement without completing that process. That's why we are saying this is unlawful.
Now, just very quickly, I know you're going to court. What happens if you lose that battle in court? Will your employees go on strike?
No, we don't encourage our members to break the law. You know, that's why we are a law-abiding union. You know, that's why we decided to take Eskom to court for it breaking the law. You know, we believe Eskom is breaking the law. We're taking them to court, and we believe we have checked the case laws. We have checked the Act, the LRA. We are talking to Solidarity and NUMSA. We are consulting with different lawyers. And then the opinion is the same, to say that Eskom is not supposed to be implementing this 1.5% before the process is completed.